7:41 this morning. Parents, do you know what your child is doing on social media? The state of Utah just passed legislation that will soon limit a minor's social media use and require parental permission for them to use TikTok, Facebook, and Instagram, the popular apps. The governor signed two bills that are set to take effect next March 1st. The law will prevent children from using social media from 10:30 at night until 6:30 in the morning. Also require age verification to join social media, as well as allow the opportunity to sue these apps on behalf of children who claim they were harmed by social media. And joining me live this morning via Zoom from Bloomington is Asaf Lubin. He's an associate professor of law at the Indiana University Maurer School of Law, as well as a fellow at IU Center for Applied Cybersecurity Research. Professor Lubin, thanks for joining us this morning to talk about what's happening in Utah.
Thanks for having me.
Yeah, your research centers on law and technology and how it actually relates to the regulation of cybersecurity harms, liabilities, and internet governance, to name a few. What are your thoughts about this law restricting social media use for minors?
Look, overall, we might say this is a good thing. We have a state trying to protect children from the harms that we've now documented from the usage of social media. At the same time, however, this is an experiment, right, and there's a lot to be concerned about with this particular legislation. Now, let me just give you one example. That is the age verification requirements that you elaborated about. It's unclear how these companies are going to engage in the collection of information to determine the age of the child. Is there going to be a requirement for biometric data collection? I note too that the law explicitly says that the companies shall not allow a minor to bypass the restrictions, and they should generate, quote, acceptable forms and methods of verification. But we basically outsource back to the companies the power to decide how to do that very act in question.
Right, and how would this be enforced, and is it possible to enforce it?
Right, and so we've seen in the past, there's a federal regulation called the Children Online Privacy Protection Act, or COPPA. It deals with children under the age of 30, not under the age of 18 as the Utah law, but it too had certain restrictions. And so what children had done, as teens often do, is bypass the restrictions.
Absolutely.
They just lie about their age. And so how do we enforce these things is something that will still be have to be determined.
Yeah, our kids are very, very, very smart. Let's talk about the privacy risk associated with this new law.
Yeah, so another aspect of this law that is unique is that it requires parents to have access to the passwords to the account of their children, as well as access to content that is being produced by the child or that the child is receiving. And the logic, again, is a good thing. We've seen children suffering from depression or suicidal thoughts. And so having parents have access to that information in early time could result in prevention. At the same time, however, this can out LGBTQ kids. And so how do we think about privacy of children as part of this model where we're providing access to parents to information is a very open-ended question. Just another example here is anonymous posting. So very popular apps like Reddit or Snapchat allow children to go anonymous, to use pseudonyms instead of their real names. Are those apps going to go away? These are all hard questions that the Utah law currently doesn't answer.
We have about 30 seconds to go. I want to get into a couple of questions. Let's talk about the legalities surrounding this law, and it's basically setting the states up for tons of lawsuits.
Correct. There's going to be a lot of questions around the First Amendment implications of this, as well as the implications for Section 230, which is that law within the Communication Decency Act that immunizes these companies from liability. So how do we apply immunization from liability while simultaneously introducing liability is something that courts will undoubtedly have to answer in the years to come.
And do you think other states will, look at what Utah is doing, as well as this becoming a federal law at some point quickly?
So we already know that Arkansas, Texas, Ohio, Louisiana, and New Jersey are looking at parallel laws. There's a call for the federal legislature to intervene as well. It remains to be seen. I think that what we'll see is that each of these state laws will generate effects that then will set precedents and challenges in courts, which will generate what the law is over the long haul for this issue.
Asaf Lubin, an associate professor of law at the Maurer School of Law at Indiana University. Thank you so much for your time and your insight. Really do appreciate it.
Thank you so much.